You're not gonna do it yet. You can turn your volume later.
Just a reminder, please remember that this is a court setting. There is no walking, no driving. Please be in a suitable area where you can hear the judge and your video be on. If you're walking around, I will turn your video off until it's time to address your case. If you need to move around or do anything, please turn off your video or I will turn it off for you.
Good afternoon, everyone.
Good afternoon, Judge.
Good afternoon, Your Honor.
All right, we're ready to start.
Yes, ma'am.
What name you said? I can't hear.
The reset date for the SAP is going to be August the 15th.
Okay. August 15th. Got it. I see PD Kim needs to interview someone.
Yes,
We'll see what we can do. Okay. All right. Good afternoon, ladies and gentlemen. I am Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will be the defendant's, usually the defendant's initial appearance before a state court judge. So we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. You just heard that our SAP date or reset date is August the 15th. I want to begin by reminding everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. Govern yourselves accordingly. I want to remind the defendants on this calendar that you have certain constitutional rights. The first being that you have a right to have an attorney represent you at this juncture in your case, and most of you should know who your attorneys are by now. You also have a second right, and that is the right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrence of your case can and will be held against you. The prosecutors are here and they're listening. So listen to your attorneys and again, govern yourselves accordingly. Who do we have first, deputies?
Good afternoon, it's position number 3, Ms. Haynes.
Okay. All right. This is 23 CR 004742C, Latoya Haynes, charged with 1 count of criminal trespass. Pretrial.
Third arrest, 2022 DWI, conviction out of North Carolina, and the 2019 simple assault dismissed.
All right. State.
This incident happened July 24th of this year at 400 South Preston Trail in Johns Creek. Defendant knowingly and intentionally knocked over Miss Thandaway Weeks Chapel's coffee pot by pushing it off the counter and causing it to shatter. The state is asking for a 500 surety bond. Stay away from that location, 400 South Preston Trail in Johns Creek, Georgia, and no further contact with the defendant, the victim. And
What's
I
the
would like to
victim's name?
Miss Thandaway Meeks Chapel.
Your Honor, I apologize for interrupting. I'm the attorney for Ms. Thandaway Meeks. She is on the Zoom. She's a listed victim, but she is also a cross defendant. This Ms. Haynes is her partner. That is their marital home. She wanted me to come on here and at least let the court know that she does want contact with Ms. Haynes, and she does not want a stay away from their shared marital home, as she has one now, and we're actually working on a bond modification for Ms. Meeks' case to modify the same condition.
Okay, but I don't have both cases on my calendar today. The other one has already been heard, is correct? Okay,
Yeah,
Your
Jeff.
Honor, I'm attorney Kofod, and I am representing the defendant in this case. I spoke with her yesterday. She also does not want a stay away order, as her wife does not. They share a 13-year-old child who will be starting school on Monday for the first time in Johns Creek. According to both parties, this was an accidental breakage of a coffee pot. There was no violence. There is no history of violence in the relationship. They're both incredibly concerned for one another. Ms. Haynes is a veteran. She has ties to the community. She poses no flight risk. She takes care of the marital home. And it was just an accidental breakage of her own coffee pot. She's a little bit clumsy, she stated, and this was not a family violence issue. So both parties feel that they would love to be in the marital home together to prepare their daughter for school, that this is very difficult for their child right now, and that there is no history of violence between the parties. So we would request that there be a signature bond for my client and no stay away order. If Your Honor decides that a no further contact order must be issued with the bond, we would request that it just be a no further violent contact order.
And this happened on July 24th.
Yes, Your Honor.
And, but the arrest wasn't until yesterday.
Yes, Your Honor, that's correct.
Your Honor, I can clarify that. Ms. Haynes turned herself in when she was contacted by the Johns Creek Police Department, and they alerted her that they did not arrest anybody when they first came to the residence. They just took a report and then issued warrants later and then contacted both parties, and they both turned themselves in willingly to the jail.
And Your Honor, I was advised by my client the same thing, that they were having a verbal argument, as couples do, that they decided it was the best interest of their relationship for Ms. McMahon's client to go outside and my client to stay inside the house so they could separate and de-escalate their argument, which was solely a verbal argument. Out of habit, my client locked the front door, as one does when their front door is unlocked, and went into the back of her home to play with some younger family that was visiting from out of town, and did not hear that her partner was trying to get into the home. The police were contacted solely to get her partner access to the home. So neither of them wanted this to escalate. The police left, and according to my client, she was advised that a superior, the police did not want to file charges, and a superior that was not present at the scene told the police that she would like them to file charges.
Well, the state has recommended a $500 surety bond. So that's a pretty low bond. But I also usually like to, if possible, when possible, hear from the victim, but I do understand in this instance why I cannot. And they both have very eloquent attorneys advocating on their behalf, and I do appreciate that.
Your Honor, the victim is voluntarily willing to participate in this call as well.
Is she on
She is
the?
on the Zoom. She is.
She is on the Zoom, Your Honor.
And
Okay.
if you want to unmute yourself. There you go.
Okay, I'm sorry, I didn't see the name. It's a different name to come up. Good afternoon. Do you wish to address the court today?
Sure. Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am. Yes,
All
Your
right.
Honor.
You can put your hand down. And let me ask you two questions to start off with. First question being, are you in fear of Miss LaToya Haynes?
No, ma'am.
Okay. Do you want to have contact with Miss LaToya Haynes?
Yes, Your Honor, please.
Do you believe that you can have contact that will be nonviolent?
Yes, Your Honor.
All right. Any cross-examination or anything from either counsel?
I would like to add that when visiting my client at the jail last night, she wanted me to express to her partner through her partner's attorney that she loves her very much and she misses her very much, and she hopes that this can be resolved. She didn't see any need for any of this, as I believe her partner didn't. And she also stated, while getting a little weepy, that she thinks that she can't imagine a better partner than hers, that there have been issues that they've been going through due to her heart issues that the VA has been addressing, and some stressors from being pushed back time after time at the VA hospital. And that, can cause stress in a relationship and verbal arguments, but there has never been any physicality between them. And she also does not fear for her safety with Miss Meek.
All right. I'm going to order a $1,000 signature bond, and that signature bond will be through the jail. I'm going to order a no further violent contact with the victim. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And I think that's all I'll order at this time.
Thank you, Your Honor.
All right, you're welcome. Thank
Your Honor.
you.
That completes my
Thank you.
business. May I be excused?
Yes, you may.
Thank you.
Thank you.
Position 4, Howard.
This is 23 CR 004743J. Kathy Howard. I hear an echo.
Your echo.
Huh?
It's coming from you. It's a third arrest. Last arrest was 1978 for theft.
Hold on a second. It's a terrible echo. Whoever iPhone is, can you mute yourself? In the red top on. Okay, thank you. All right, go ahead, pretrial.
It's a third arrest. Last arrest was in 1978.
Oh,
Before I was born.
all right. State.
Thank you, Your Honor. This offense happened January 30th of this year at 125 Milton Avenue in Atlanta. Officers received a call from the victim, Miss Charles, reporting a fight which she was in that left her with a busted lip, cuts on her right hand, and effects of pepper spray to her face. The defendant and Miss Daisha Charles, who is the victim, were having a phone disagreement. I guess the Miss Charles was talking about a boyfriend that had passed away, and the defendant was not supportive. And defendant claimed that, the boyfriend was dead and she needed to stop crying over him. The phone call ended, and 2 hours later, defendant called Miss Charles again and asked if she was still crying over the deceased boyfriend. And Miss Charles the victim let her know that if she wasn't going to be supportive, then she could leave her alone. And then around 9 o'clock that same night, while Miss Charles was using the restroom, she heard a knock at the door and someone say, "B word, come outside." Before she could get to the door, the defendant opened the door, pulled Miss Charles outside, and began hitting and kicking her. Defendant was there with both her daughter and granddaughter, at which point all three individuals began hitting Miss Charles, where she could only put her hands up to prevent herself from being assaulted more. The fight moved from the hallway to the elevator, and at that time, that's when Miss Charles was sprayed with pepper spray. And then subsequently, defendant posted a video of the incident on IG when asked to come down to the station. The defendant said that Miss Charles took the first swing and hit a minor child, KW, in the shoulder, and claims that just KW was the one that actually hit Miss Charles. Considering how offensive the issue is, the state is asking for 3,000 surety bond for the first for battery and 500 for both the contributing to delinquency of a minor and cruelty to children, no further contact with the victim, stay away from 125 Milton Avenue, Atlanta, Georgia, no alcohol, drugs, or weapons, Your Honor.
All right. Ms. McLeod? Oh, you're on mute.
Oh, I'm sorry. Good afternoon.
Good afternoon.
My client is 64 years old. As Petral has mentioned, she has not been in any kind of trouble and certainly not anything related to violence since long before most people on this Zoom were born. My client tells me that the complaining witness is someone she has known pretty much all of the complaining witnesses' life. And the warrant itself states that the complaining witness said that my client is someone she considers like a mother to her. My client denies that what the warrant states is what happened. She denies that she attacked Dasha at all. She says this is someone who's been a part of her life for a very long time and was grieving over something. It was a total misunderstanding. I would ask the court to give my client a signature bond so she can get out of jail. I would ask that the signature bond be through the jail, Your Honor, because my client tells me that she is totally incompetent when it comes to technology, and she would not be able to do any of that reporting via Zoom or so on. And plus, given her history, Your Honor, and the fact that she tells me that she is retired, she said she actually thought about getting a part-time job and was just being interviewed by Atlanta Public Schools when this came up, and she voluntarily turned herself into the jail. So she's absolutely not a flight risk, Your Honor. Nothing further.
All right.
Your Honor, if I may I please sound for Miss Charles, who's currently on the Zoom today?
All right, Miss, is it Deja or Deja Charles? Miss Charles, are you on the Zoom? I don't. Oh, are you Miss Charles? Who's this in the top red with iPhone who keeps unmuting?
I'm Miss
yourself?
Charles.
Are you
I'm
Miss
Miss Charles.
Charles?
Yes,
Bluetooth
pairing. Yes,
Do you wish to address the court?
yes,
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
yes.
All right, put your hand down. What would you like to say to the court briefly?
I beg your pardon?
What would you like to state to the court today? And let me ask you two questions first, and then we'll cut to it. Are you in fear of Miss Kathy Howard?
Yes.
Okay, do you want to have any contact with Miss Kathy Howard?
No,
You don't?
no, I want to have no contact.
Okay. All right, any cross-examination?
No, I don't want, I just want to press charge and I don't have nothing to say. I just want to press charge and I don't want to have nothing to say.
Okay, that's fine. And so you can mute yourself, Miss McLeod or Miss it's been a minute since you've been on my calendar today. So tell me how to pronounce your last name again. ASG.
Nimini, Your Honor.
Nimini. Okay, thank you. All right. Do you all have any cross-examination for this witness?
I do not, Your Honor.
No, Your Honor.
Okay. All right. You can, she did. You can mute yourself, Miss Charles. Thank you. All right. I'm going to, now let me ask this, Miss McLeod and Miss Nimini, who lives at this Milton Avenue address?
I believe that the complaining witness lives there, Your Honor. That's my understanding.
Okay. All right. So
I
Miss
do not
Howard
think
is
that is
not.
my client's home, but let us find out. I was under the impression.
He said no one lives there. Neither one.
No one lives there? Okay. Thank you. All right. I'm going to order the $4,000 signature bond through the jail. I'm
Thank
going to order stay away from 125 Milton Avenue for what it's worth. I'm going to order no further contact with the victim, Daisha Charles. And I'm going to order no drugs, alcohol, weapons, or guns while on bond. And I believe that'll conclude.
Judge,
This-
what's the breakdown?
Oh, I'm sorry, the breakdown, $3,000 for the battery and $500 for each of the other two charges for a total of $4,000 SOB jail.
Thank you.
All right, thank you.
Thank you, Your Honor.
All right, thank you.
Position 6, carried.
Okay. This is 23 CR 0047488A. Madeline Jarrett, charge of 1 count of battery, family violence, a 2nd count of cruelty to children in the 3rd degree. Pre-trial. First, okay. All right. State.
Hi, Judge Mincy. So
Good
good to
morning.
see
I was gonna say good morning, good afternoon. How are you? Haven't seen you in a while.
you. Good, I know. Well, as far as this case goes, on August 1st of this year, the defendant battered her husband, Jason Jarrett, in front of their 9 and 6-year-old children by punching him in the face, causing Mr. Jarrett to fall to the ground and left a red mark on his face. Your Honor, our victim advocate had an opportunity to speak with Mr. Jarrett. He confirmed what's in the warrant, that they live together and they are married and share 2 children. He also stated that they were in an argument when the defendant hit him and that she does have a temper and needs counseling. He also stated that this has happened in the past, but the police were that he the defendant, but he didn't want.
Ms. Mitchell, your audio is very bad. Ms. Mitchell, we
Can't
cannot
hear
hear
you.
you. You sound like a robot. You're frozen right now on the screen.
Right.
Sorry to interrupt you, but
Can you hear me now?
we can hear.
Nope, I think you're frozen again.
Yeah, you're frozen. You're gonna have to probably adjust your internet connection.
Now it looks like
Back
you're
off and
back.
off, back on, we would go from there.
Hello?
Now we can hear you.
Okay. I'm
That's
sorry.
better.
I'm having a lot of Wi-Fi issues today.
Okay. All right. I
Were
think we can hear you. Let's start again, kind of in the middle where you were.
in the middle?
Yeah, I think we heard the beginning. Not trying
Okay.
to start all the way over, but
Yeah. Well, I can just let me
abbreviate.
see if I can, abbreviate it a little bit.
Okay.
So our victim advocate had an opportunity to speak to the victim, Mr. Jarrett, and he confirmed what's in the warrant and that the defendant is his wife. He stated that this has happened before and that she does have a temper and that he believes she needs counseling or needs help. And he's also stated that this has happened in the past, but that the police were never involved. Your Honor, the state's bond recommendation is a $3,000 surety bond, no further contact with the victim, stay away from the incident location, which is 140 Brooks Glen, Roswell, Georgia, a 1-day anger awareness, and no alcohol, drugs, and weapons. The reason the state is requesting and no further contacts with the victim is because the victim did state that this has happened before and they have 2 children and this incident took place in front of them. The victim, Mr. Jarrett, I believe is on the Zoom. So if he would like to speak in regards to that, your judge can call on him.
Okay. Is he on the call?
Yes, Your Honor.
On the call.
Yes, yes, can you hear me?
Yes, but he
I
needs
can
to video, sir.
hear you, but we have to see you.
Okay, can you see me now?
Okay, there you go.
Okay,
right.
yeah, Ms. Mitchell, we did talk, but as I
Hold
stated,
on a second. Hold on a second, Mr. Jarrett. If you wish to address the court, I will have to swear you in first.
yes, ma'am.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. And what would you like to state? I don't want you to repeat everything that was just said, but what would you like to say to the court today?
I want her to come home. This did not need to happen. This is a terrible misfortune. I love my wife. I want her home. Her kids want to see her. I want to see her. Whatever I need to do to make that happen, please, I beg you, don't, the no touch, just, we can work this out, and I want this to be an opportunity for us to try to work on this. I had no intention of making a claim that I wanted to not have any touch. I don't want whatever the other option was, no touch violence, that whatever that was. That's what I want. This is throwing me a curveball here. She is safe. She loves her children. We need to work on our family, no doubt about it. We've got some issues to work out, but I, under no circumstances, am asking for her to have any kind of a restraining order whatsoever. I want her home.
All right, this just happened yesterday.
Yes, ma'am.
And so there was obviously something that went on because police were called, right?
Yes, I believe that I don't know for sure, but my wife called the police. I did not call the police. I think she called the police, and then she thought better of it, but it was too late. And by the time they got there, my daughter had answered the door and explained it to the police. And of course they did what they were supposed to do, but this just should not have happened. Whatever we need to do, if you want to mandate counseling, if you want to mandate any kind of treatment, whatever it is you do, but please, she needs to come home.
I understand, but let me say this to you.
this.
I understand, but I need to make sure everybody's safe and that there's
They're
been the
safe.
ample, hold on, and that there's been the ample cooling down period. I'm not here to order counseling or things like that for you to work on your marriage. That's something you all have to do. This is
Yes,
a bond
ma'am.
hearing. This is not your trial. And this is not that proceeding at this point. This is early in the case. And so hopefully you all will do what you need to do for your family's sake and for the safety of everyone in your household. So let me hear from your wife's attorney, and then I will make a ruling, okay?
Okay, I didn't even know she had an attorney, but yeah, sure.
She has representation. She has to at this point. Okay.
Okay. All right.
All right.
Yes, ma'am.
Thank you.
Yes.
Kim.
Yes, Your Honor. My client is 42 years old, and she has been homestay mother for her two children. They are very young, 6 and 9, and they have to go back to school. This is the busiest time. And my client has been very active in the community. They have been here. I mean, she was born and raised here in Georgia. She has a strong ties to the community. She's a parent teacher, PTA for kids schools. She donates a lot of things to the charity. She's been involved in the community a lot, and she's not a flight risk. And she's the one who called the 911. She denies the allegation. We would like to request for a signature on bond. She has an associate degree. She didn't really get the degree, but almost like a associate degree. We believe that this is her first incident ever, and she wants to have no further violent contact with her husband and children as well, so that way she can take care of kids. And also, Your Honor, that house is marital property, so my client owns 50%, so she has a right to remain their place. So that's what we would like to request for. Thank you.
Okay, PD Kim, that's a new one for me. It's marital property, but I want to make sure that everybody's going to be safe. That's my first concern as the judge, and that these children will be safe and they're going to be in a safe environment as well. I understand it's a stressful time. School's getting ready to start, but it ought to be a less stressful time. And I do understand that the victim, Mr. Jarrett, is here and wants his wife home. I usually don't order someone to go back in less than 24 hours because of the ample cooling down period and making sure that there has been the cooling down period. I don't know if Miss Jarrett has anywhere else to stay or to go, but I'm going to hope that if I allow her to go back home, that the police won't be called again.
No, ma'am.
And that they will begin to work on it. So I'm going to, what was the state's recommendation on bond?
Your Honor, it's gonna be 3,000 surety on the first count and $500 surety on the second count.
All right, I'm going to order that $3,500 signature bond. And on that signature bond, it will be, I'm going to order that signature bond through pretrial per the judge. And with that, I'm going to order the one-day anger awareness course through pretrial. And I'm going to order no drugs, alcohol, weapons, or guns while on bond. And I think that's all I'll order at this time. That's a $3,500 signature bond through pretrial, $3,500, Ms. Lewis.
Who's that
And
contact?
they're
I'm sorry.
violent.
Oh, and I'm sorry, no further violent contact with the victim.
Thank you.
Okay.
Thank you, Judge.
All right, you're welcome. Good luck to you.
Thank you. When can I come pick her up?
24 hours.
What?
As fast as you can.
Can I come now?
It's
8 to 24 hours, so no.
No,
Listen,
we have to finish court. We have to sign orders and get them over to the jail.
and the system won't be updated till after 6 p.m. this evening, so don't come.
Will I be notified?
No,
All right, I won't take up any more of your time. Thank you, Judge.
Anytime after 6, you can go to the jail.
Thank you.
Okay.
Evans. Position 2. Evans.
Okay.
Evans, okay.
This is 23 CR 004737G. Julius Evans charged at 1 count of criminal trespass, retrial.
He got 49 total. Last arrest was in April for theft by receiving. That's open. 23 CP 217914. On probation, theft by receiving possession of a firearm by convicted felon. 19 SC 167176. July 2019, they gave him 1 year to serve, followed by 4 years probation. He got several probation violations in his history. 2015 failure to appear, and that's it.
Okay. State.
Yes, Your Honor. This incident happened yesterday at 2981 Grand Avenue, Atlanta. Homeowner and victim, Mr. Clifford Patterson, received a call from his brother who noticed that the curtains and a blue moped were at the residence that were not supposed to be there. The officers were called and they surveyed the area and made an attempt to open both the front and the back door, but the keys were not working. There were 2 individuals that were seen in the home, one which was defendant, Mr. Evans. They had the victim, Mr. Patterson, claimed that no one had any prior authorizations to be in the home. A neighbor has seen the defendant with other individuals, 1 white female and another 2 Black males, and they claimed that they were there to clean the residence and they asked for help, and that's how they stayed in the home. The state was able to talk to Mr. Patterson, and he claims that he does not know the defendant, and his family actively lives at that residence. They broke into his home and stole some items. We do have on a warrant that a 16-inch TV was missing. I would like to sound for Mr. Patterson if he's on today. But the state is asking for $1,500 surety bond. Stay away from 2981 Grand Avenue, Atlanta. No further contacts with Mr. Patterson. no alcohol, drugs, or weapons, Your Honor.
All right. Ms. Moses Counts, is this your case?
Yes, good afternoon, Judge.
Good afternoon.
Yes, so my client is 42 years old, Your Honor. He does have an address in Covington or off Covington Drive in Decatur, Georgia, Your Honor. After speaking with him, he did express to me that he is working part-time in construction. He would qualify for the services of the public defender after today, so I have assisted him with that application. As it pertains to his ties in the state, he's been born and raised here, so he does have significant ties. I just want to stress that per the affidavit for arrest, my client was not charged with any type of theft offense. This was just a simple note in the affidavit that this home did appear to have a missing TV. However, from the officer speaking with a neighbor, they saw at least 5 individuals coming in and out of the house the day of this arrest. And so, again, my client has not been charged with any theft offense. And per the affidavit, he was given permission by someone to be present in the home. And so, with that stated, this is a nonviolent offense, Your Honor. I would ask for your consideration of a signature bond. Nothing further.
Okay. I'm going to order a $1,000 surety bond. I'm going to order a stay away from the 2981 Grand Avenue in Atlanta. I'm going to order no further contact with the victim, Mr. Patterson. No drugs, alcohol, weapons, or guns while on bond. And that will be it, 1,000 surety.
Thank you, Your Honor.
All right, thank you.
Your Honor,
Yes.
I don't have any money to pay this $100 security bond, ma'am. Can you please give me a signature bond, ma'am? I will come back to court. I promise you, Your Honor. Please, like, I got my grandbabies, they stay with me. Like, and I'm trying to help my granddaughter and get back in school. Like,
Mr. Evans, this is being recorded and the prosecutor can hear what you're saying. I would really ask that you would remain silent.
yes.
All right, thank you.
She ain't changing that, right? Go ahead. Man.
Position 5, Mr. Jackson.
All right. This is 23 CR 004746H. McKinley Jackson, charged with 1 count of battery family violence pretrial.
4 total. Oh, no, I'm sorry, 18 total. Last arrest was 2018 probation. He had a reckless conduct conviction from 2018. 2015 simple battery DV conviction. 2014 contraband in a penal institution. And a 2008 domestic assault. That's it.
All right, State.
Thank you, Your Honor. This offense happened December 31st of 2022 at 954 Hightower Road in Atlanta, Georgia. Officers received a phone call from Miss Linda Webb, the victim. Defendant and his wife were at home watching TV as they were drinking beer. When they began arguing, Mrs. Webb, the victim, began cursing at her husband. A defendant picked up Mrs. Webb's phone and forcibly struck her in the head, causing a laceration on her head. They are in a relationship and they do live with each other, but they don't share any children. Considering the defendant's violent behavior, I do see a family violence conviction from July of 2021. The state is asking for a 3,000 surety bond, a stay away from the marital home, 954 Hightower Road, no further contact with Ms. Webb, no alcohol, drugs, or weapons, a family violence intervention program. And I would like to sound from Ms. Webb if she's currently on the call today.
Ms. Webb. And you say Ms. Webb is married to Mr. Jackson?
Yes, Your Honor.
I don't think Ms. Webb is on the Zoom call. Go ahead, Ms. Moses Counts.
Yes, Your Honor. My client is 68 years old. He does reside at the 954 Hightower Road address. He is retired, so the income that he does have is based on Social Security, and so he would qualify based on that amount for the services of the public defender after today. Your Honor, he has been present in the state for over the past 5 years, and so he does have ties here, connected here, and so I do not believe that he would be a flight risk. From pretrial, it appears that he has not had an arrest for the last 5 years, and so I would ask for your consideration based on that for a signature bond. If not that, then as low of a bond as possible based on his income limits.
All right. And I did not, or did I miss it? What's the state's recommendation again?
3,000 surety, Your Honor.
All right, I will order a $1,500 surety bond. And I will order a stay away from 954 Hightower Road. No further contact with the victim, Ms. Webb. No drugs, alcohol, weapons, or guns while on bond.
Your Honor, I would ask, because this is their marital home, that if he is able to bond out, if she's not present, that he would be allowed to remain. Otherwise, I would ask for a one-time visit with law enforcement for him to be able to retrieve his property.
All right, a one-time escort with law enforcement to retrieve your personal property.
And if she's not present, he would be allowed to remain.
I don't know about present. She just might be out of the house that day.
Well, if
They
she's
would
not,
almost have to sweep that house to make sure there's no personal belongings. I hate to put the officers in that position, but I have in the past. If they can inspect the home, and I'm sure Ms. Lewis will put this in the bond conditions and determine that Ms. Webb does not live there. I don't know if we have any evidence that she intends on moving. Sometimes they'll say that, or she hadn't resided there since this incident, because I know this incident did happen December 2022. So
right, and it's his income that's providing this that space for them to live there. So if he's in custody, that's my concern, is that would be the basis for why she would not be present at the home. So if he's able to bond out, and she's not returning, I just want to be sure that he's allowed to remain.
all right, Ms. Lewis will put that in the bond. If the officers inspect or sweep the home and determine that Ms. Webb does not live there or have any personal belongings there, then he can stay as long as the officers can determine. But if they can't determine that or see a lot of her belongings there, then Mr. Jackson, you cannot stay there, or your attorney will have to ask for a bond modification at a later date.
What was it, 1,500 what?
1,500 surety.
Thank you, Judge.
Thank you.
Position 7, Mr. Motley.
Okay. This is 23 CR 004744B. Adrian Motley, charged with 1 count of battery family violence, 2nd count of battery against a female who's pregnant. Pretrial.
His 4th arrest. I didn't see any violence in this issue. Last arrest was 07 out of Florida for possession of marijuana and tampering with evidence.
All right, state.
This incident happened March 2nd of 2022 at 4417 Bell Camp Road in South Fulton. Officers did receive a walk-in complaint concerning an incident that occurred at the previously mentioned location. Ms. Jocelyn Terrell, who is currently on the call, and I would like to sound for the appropriate time, stated that her and her boyfriend were engaged in a verbal dispute in their bedroom when defendant pushed her out of the room and onto the ground. And then defendant did it's in the warrant, choked Miss Terrell and forcibly struck her in the face with a closed fist. When Miss Terrell asked the defendant why he was doing that to her, while she was carrying his child, defendant did state that he did not care if the child died. Ms. Terrell and the defendant do live at the same residence, and there claims to have been previous abuse in the past, abuse to the point that Ms. Terrell did have a miscarriage in the past. Although the state was able to talk to the Ms. Terrell today, and she does want to have contact with the defendants, the state is asking for no further contact. Stay away from the 4417 Belcamp Road, no alcohol, drugs, or weapons, and a 3,000 surety bond.
How's the breakdown?
2,000 for the family violence and 1,000 for the battery towards a pregnant female.
Okay. Moses counts.
Yes, Your Honor. My client is 49 years old. He does reside in Fairburn, Georgia. He does have two minor children, aged 7 and 15 months, that live in the home with him that he does provide care for. He has excellent employment. He works at AT&T as a network IT specialist and has kept that employment for the past 8.5 years. Based on his income, he would not qualify for the services of the public defender after today, and so he would have to hire his own attorney, as he does have income over our limits. Your Honor, he has significant ties to the state. He's been present here for the past several years, since 2015. Your Honor, from the allegations stated, I find them quite bizarre, especially for someone who has absolutely no violence in their history, as stated from pretrial. And so I would urge the court to please consider that today for the purpose of bond. Furthermore, Ms. Terrell is here, and I'm sure she would like to speak, but even so, in the affidavit, she stated she did not want him to be arrested. And so I'm just going to ask for a signature bond. This man has had absolutely no violent history, not even an arrest prior to now. And so I would ask for your consideration of the signature bond, allow him to return to his children. And that's nothing further.
All right. And you're saying no arrest. He has history out of Florida, I thought they said.
For possession of marijuana, Your Honor. So, of course, not a violent offense. He has absolutely no violent history, not even an arrest for violent offense, is what I would like to bring to the court's attention.
Okay. All right. Ms. Terrell, do you wish to address the court today?
Yes, Your Honor. I would love to address the court today.
Let me swear you in. Let me swear you in first. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, thank you. You can put your hand down. And so are you in fear of Mr. Motley?
Yes, we live together in the home, and the same child that was in the incident report, which is only an incident report and not the truth. This is a live child. He's just asleep. So I know I can't put him on camera, but this is the child. And if I can just let you know, nothing happened that way. I don't want to prosecute Adrian at all. He's a wonderful, wonderful fiance. He's great to our children. I just don't want to move forward with anything. Like, if I can just erase this, as this has just been troublesome to us all, I would. And yeah, he's a great man, and he doesn't deserve any of this, any of it. If I could switch positions, just understand, I would, because his mental is so much better than mine. So I'm just letting you know, Your Honor, that I would truly rather for him just to be out rather than me to bear with the kids. I have, you see this? That's 2 work computers and this, and me also breastfeeding, and I'm not trying to go there. I'm just letting you know, as a mother, I need him.
All right. All right, thank you. You can mute yourself.
Well, just one thing, Your Honor, I just want to clarify, because your first question to her was if she was in fear of him, and I don't think she heard the answer, the question correctly. So I just wanted to make sure she.
Yeah, I determined she didn't hear my question, right?
Yeah, okay.
All right, and I'm assuming her answer would be she's not in fear of them. She kind of
Correct.
answered it roundabout, but I thank you for that. I
I'm
did
so
hear
sorry.
you, Miss Terrell. I
I'm
understand. I understand. You're not in fear of him. Is that correct?
Correct, Your Honor. Yes, correct, Your Honor. I'm not in fear. He's my protection. That's why I'm hallucinating. He helps me. He really does. And I'm just, God is good. That's all I'm going to say. So I don't have a lot to say, but that's what I'm going to say.
All right. Thank you.
Yes, ma'am.
All right. I'm going to order $3,000 signature bond. And with the signature bond through the jail, there'll be 2,000 on the battery, 1,000 on the second battery against a female who's pregnant. So it's a total of $3,000 signature bond through the jail. I'm going to order no further violent contact with the victim. And since he does have some means, I'm going to order a one-day anger awareness course that he should be able to find and pay for. No drugs, alcohol, weapons, or guns while on bond. And that should conclude my order.
Thank you, Judge.
Thank you.
Position 8, Mr. New.
Your Honor, before we begin, I was interviewing Mr. New, and he expressed to me his intention of entering a plea today for these charges. I did reach out to ASG Shelley Falk requesting a plea offer and did not get a response back. So I'm not sure if any of the ASGs on for today have an offer, but it was his intentions to enter a plea, which he understands will be pro se, but I did want to let the court know that that was his intentions. Otherwise, if he is not offered anything, I would be prepared to move forward with a bond argument.
And also, I would have to get a court reporter on the line, and I would have to, if he's gonna go on probation, I would have to get probation on the line. And that would take some time.
Judge, you're muted, so I can't hear you.
Forgot I did that. Sorry. Mr. New, do you intend to enter a plea today?
Yes, ma'am.
And you intend to enter a plea pro se and not represent it?
Yes, ma'am.
Okay, and you understand there's consequences to that
Yes, ma'am.
of representing yourself. All right. State, I don't know if we can take this plea today. Where's the plea paperwork?
Was he offered?
I don't even know if he was offered a plea.
Yeah, that's what I'm saying. Nobody ain't said nothing.
Nobody's saying nothing, so if there's no plea offer on the table, then there's no plea. We just need to go forward with the bond hearing.
Miss,
I don't know if he could be reset till tomorrow for a plea, because again, I did my due diligence and nobody responded. I attached multiple ASGs that consistently do this calendar and nobody got back to me. So I mean.
Well, who told him there was a plea offer?
Nobody told him it was a plea offer. He told me he did not want to move forward with any type of not guilty. He wanted to take a plea today, and so I reached out to the solicitor's office to let them know that he wanted to take a plea today.
Oh, okay. So we don't know that they offered one. He wants to take a plea.
Correct.
But we don't. Okay, I got you now.
So I don't know again if Miss Nimini or Miss Mitchell know that there's a plea prepared. Or
if I may speak, so it's not customary for us to take a plea at this point during SEA, and we don't feel comfortable with it. We, our attorneys, as far as Shelley and Ian go, they are in a symposium and are out of the office right now. So probably why they didn't get a chance to reach back out to you. But if he's pro se, we can make a note in our filing that he would like to take a plea when it is that time in the next step of this process. But as far as right now, we're going to continue with the bond hearing.
Okay, thank you. All right, did you hear that, Mr. New? This is going to be your bond hearing. Can't do anything but that.
Can I say something?
You can ask a question.
Yes, I would like to enter a plea of guilty, and I would like to get served today. That's not possible at all?
No, not possible.
Okay,
No.
one more
This
thing.
is-
then. So basically, my situation is and I appreciate you, Judge. When the officer locked me up, he didn't.
Not going there. This is not a trial. I'm not gonna weigh evidence. That's already been determined, at least to get you this far.
Can I
This
just, one small thing, just one thing. Just one small thing. He didn't let me get any numbers out my phone, so I can't bond out. So I would like to know if I can get a signature bond on my bond loader, please.
Well, I haven't even heard your case.
Okay.
So first of all, I have to hear your case and I need to hear your history. So let me do my job and then you hold on a second and don't be too anxious with it.
So if I did want to enter a plea of guilty, could I come back tomorrow? It won't be tomorrow?
Oh, I don't know that. I do not know that. That is not my.
So if I want to enter a plea of guilty, could I get sentenced today and get the time today?
No, it will not happen today. We've said that about 3 times. Cannot enter a guilty plea today. I don't even think there's a plea offer on the table. So there is no guilty plea. This is going to be a bond hearing. Now, do you want to participate in bond hearing or you can go back to your cell and wait till tomorrow?
I can get sentenced tomorrow?
I cannot promise you that. I probably won't even be the judge tomorrow, but the state will have to have time to determine with the facts of your case, whether they're even entertaining a plea offer. I think you're trying to be the lawyer for yourself and you're making some grave mistakes. And I would tell you to listen to your court-appointed attorney before you make some bigger mistakes to hurt your case in the future.
Yes, ma'am. And I'm not trying to do it.
Mr. New, can you be quiet at this point so we can move forward?
Yes. So do you want
you.
to have this bond hearing today or not?
Yes, Your Honor. Can we move forward with bond?
Okay. All right. Go ahead, Ms. Nimini.
Thank you, Your Honor. This incident happened yesterday, alongside Northside Drive and then MLK Drive. Officers identified the vehicle that Mr. New, the defendant, was driving. They were traveling behind him and he was driving a white Rolls Royce with expired plates, traveling at high speeds through a clear construction zone. And then defendant was also seen passing vehicles on the left over clearly marked double yellow line, also known as the no passing zone. Defendant was also seen cutting off traffic. Officers were able to catch up with him, turn on their emergency lights, which he did not evade them, but he did take some time to pull over. And then he was arrested. Considering the large amounts of driving histories he has, to my understanding, been without his license since 2018. For counts 1, 2, 4, and 5, we are requesting a $500 surety bond, no alcohol, drugs, or weapons, and then $1,000 surety bond for count 3, which is the reckless driving. So I think a total of $3,000. Yeah.
You're on mute, Judge.
Tell me your recommendation again.
Yes, Your Honor. So $500 for counts 1, 2, 4, and 5. Surety, no alcohol, drugs, or weapons. And $1,000 for count 3, which is the reckless driving, based on his history of reckless driving, and his constant, and then his driving record. To my understanding, his license has been suspended since 2018.
Okay. All right. Thank you. Go ahead, Ms. Moses Counts.
Did pretrial state his history?
Actually, they didn't. I think we all got discombobulated a little bit here. Pretrial, give me the history, please.
You want the history?
Yes, sir.
25, I was talking to the PD, 25 total. Last arrest was in 2022. It's a PI conviction, but PI arrest. He got an open simple assault in state court, 21 CR 000-423E. It's 2 counts. Got the open PI charge on probation. Let's see, I'm gonna add this up. For insurance fraud, 15 SC 137361. 2016, 2017 failure to appear. 2015 suspended license conviction. 2015 another failure to appear. 2014 suspended license conviction. 2013 suspended license conviction. That's it.
Thank you. Your Honor, Mr. News, 35 years old. He does have a good address located in Atlanta. From speaking with him, he is in between employment at this time. He would not have the funds to post any type of monetary bond. He's born and raised here, so he does have significant ties. Based on pretrials, recitation of his history, I haven't heard anything driving related. So I'm opposing what ASG Nimini is speaking of. I haven't heard anything driving related. Most definitely since 2015 was the only thing, and that was a license charge. And so this to me, these are driving infractions. I would ask for your consideration of a signature bond on all 1, 2, 3, 5 offenses. Nothing further.
All right. All right, I'm going to order the $3,000 surety bond. And that breakdown again, I believe, Ms. Lewis, you heard that 1,000 on the reckless, 500 on the other charges.
$1,000 on the reckless, you said?
Yes.
And
then-
everything else is 500?
Correct. That should total up to 3,000. So $3,000 surety bond. I'm going to order no driving for anything because he doesn't even have a license.
Ma'am, excuse me, Your Honor, I have a valid driver's license. That's not true. My license is right here and it's valid. I don't know why she's telling you that. My license is right here. I have a valid driver's license. That's not true. Hold on.
Mr. New, please
be quiet, Mr. New. He doesn't have a suspended license, Your Honor. It was registration.
Okay, I apologize. All right, so I guess he can drive as long as he has a valid license through DDS. And I'm sorry, I do see it was tag and registration. Okay.
Right.
Okay, so he can drive as long as he has a valid license. But he also must have a valid tag and registration as well for any car that he's driving. And so we must obviously state that, or else he'll get pulled over again if he bonds out and is driving.
What's that total?
That total is 3,000 surety.
Thank
you. Okay. And no drugs, alcohol, weapons, or guns while on bond. That will conclude this case. I'm going to move along. I'm not going to hear any more from Mr. New.
Position 1. Position 1, have a seat. Where's my phone?
You said position 1, deputy?
Yes, ma'am.
All right, this is 23 CR 004736E, Demario Bateman. Charge of 1 count of battery and 2 counts of cruelty to children, pretrial.
This is a 5th arrest. Last was 2022 out of Tennessee. It was for drugs and possession of a firearm during a commission of dangerous felony. I'm sorry. 2020 battery DV, theft by taking, dismissed. That's it.
Okay. All right, state.
Yes, Your Honor. This incident happened October 3rd of 2022 at 2500 Center Avenue, Northwest Atlanta. 911 call was placed about an assault by Miss Jaja Allen, who is the victim. Officers responded to the location and spoke with Miss Allen, and she told them that she had brought her daughter to her father to visit his grandmother and the child's great grandmother when the defendant and Miss Allen began arguing. As Miss Allen tried to leave, defendant put his daughter DB in the car and turned around and slapped Miss Allen across the right side of her face, causing redness and slight swelling on her right side, in addition to a busted lip. In addition, when Miss Allen tried to walk away from the incident, defendant followed her and slapped her again while she was on the phone calling 911. The incident occurred in front of the victim's 2 children, one that the victim, Ms. Allen, shares with defendant, and another one from a previous individual. The court is asking, the state is asking $2,000 in surety bond, $2,000 for the first count, $500 for the additional 2 counts. Stay away from the location 2500 Center Avenue, Northwest. no further contact with Miss Allen, no alcohol, drugs, or weapons. And if we can sound for Miss Allen if she's present on the call today.
Miss Allen? Is it Deja Allen? All right, don't think she's on. And you said in the other two victims, one initials DV, what was the other one?
DA, Your Honor.
VA, V as in Victor?
D as in dog.
Oh, DA, okay. All right. Miss Moses counts.
Yes, thank you, Your Honor. Mr. Bateman is 24 years old. He resides at the 2500 Center Street address that was listed in the affidavit. I do want to make note that Miss Allen does not live there. She was just simply visiting with the child to allow the child to see the grandmother. So there should not be any stay away order from that address. She should be allowed to return. Your Honor, he does have 3 minor children, that 2-year-old child that he shares with this complaining witness, as well as a 9-month-old and 8-month-old babies. Your Honor, he is in between employment at this time. However, he does have significant ties. He's been born and raised here. The one battery offense prior to this that was stated by pretrial, interestingly, Your Honor, was a dual arrest with my client and the same complaining witness, Ms. Allen, in which both of their cases were dismissed. And so I would like the court to make note of that once again, it appears that Ms. Allen is utilizing the court system to get some type of point made to my client. And so based on these facts, akin to the facts of that case, which was 20 CR 002061G, I would go on to say that likely this case will resolve the same way that case did. And so based on that, Your Honor, in any limited history confined to this of any violence, I would ask for your consideration strongly of a signature bond. Thank you.
I do see that this incident occurred October of last year. So I'm
Yes, Your
assuming
Honor.
there's been the ample cooling down period. The parties don't reside together. I am concerned about the prior case between the parties, that maybe there is something going on there. And I hope it is stopped, but then, you know, we had this 2022 incident. So I'm going to order that $3,000 surety bond. That's $2,000 on the battery, $500 on each of the cruelty charges. I'm going to order no drugs, alcohol, weapons, or guns while on bond. I will order no further contact with the victim, Deja Allen. And if there is to be visitation between the children, that it be precipitated by a third party, so that he will not violate bond by having any contact with Miss Allen. And I think that'll be it.
That's a surety bond, Judge?
Surety bond, yes. All right, anything else? Don't think so. All right, thank you.
Position 11.
11.
Solomon.
This is 23 CR 004739J. Roynell Solomon, charged of 1 count of improper passing, 2nd count of driving hit and run, July 30th, 2023.
7 total. Last arrest was 2021 probation. And I saw 2015 ag assault robbery conviction.
Okay. State. You're muted, Ms. Mitchell.
My apologies, Your Honor. In this case, the victim, Ayana, spelled Aiyana, Mitchell, was traveling down Oakley Industrial Boulevard and was taking a left turn into Solstice Apartments when the defendant proceeded to pass her on the left side while she was making her a left turn. striking her vehicle. The defendant pulled into the complex and asked the victim, "What are you doing?" before driving off. The victim suffered a headache on the scene as a result of the collision. During the officer's investigation, they were able to locate the defendant via camera footage traveling down US 29 toward Union City with new damage to the right side of his vehicle. And officers were also able to confirm that the defendant was the second registered owner of said vehicle. Your Honor, the state's bond recommendation is going to be as to count one, $1,000 surety, count two, $2,000 surety, totaling a $3,000 surety bond, no further contact with the victim, Miss Ayanna Mitchell, a stay away from the incident location, Oakley Industrial Boulevard, Fairburn, Georgia, near Solstice Apartments, and no alcohol, drugs, and weapons. Your Honor, the state's concern here is defendant's risk of reoffending. He is a convicted felon. Pretrial stated he was convicted of aggravated assault and robbery in 2015 in Clayton County, where he was in confinement for 8 years. And then he also had probation violation for a felony charge in Telfair County in 2021. And then other felony arrests in 2014. So based on that, we are recommending the $3,000 surety bond. Nothing further, Your Honor.
Okay. PD Kim?
Yes, Your Honor. My client is 27 years old and he was born in New Jersey. However, he's been here in Georgia for more than 15 years and he has he's gainfully employed at Ruma Bio at warehouse worker. He's been making enough money. So he's not qualified for public defender services. However, I will be representing for the purpose of bond hearing today. He graduated from high school successfully. And Your Honor, he also has another felony charges that he has a high bond. He has to pay for the car that was impounded, and that's going to be a lot of expensive. And he just had a baby, through his girlfriend. July 28th, he has a first child and he really wants to go back and meet him. And we would like to request for a signature on bond, especially improper passing. Those are driving traffic tickets. So I think signature bond is more appropriate and reasonable. Thank you.
I guess you're telling me with the signature bond, he's not going anywhere?
Correct, Your Honor.
And Your Honor, the state would like to remind the court that the victim in this case did suffer injuries as a result of this collision.
My client denies the allegations.
What is the felony bond?
$2,000, I believe. Was it $2,000? I cannot remember clearly.
He's raising his hand. How much?
2,000.
2,000 was your felony bond?
Yes.
That's a pretty low one. It's not a high one, PD Kim. As you know, we've heard much higher. I'm a little concerned about the allegations here. And as far as, I don't know, this defendant lives in that area, to say stay away from Oakley Industrial and the Solstice apartments. So I hold on one second. All right. Did you see that message, PD Kim?
Not yet, Your Honor.
In
Thank
the
you,
chat?
Judge. Thank you.
Okay, you're welcome. Take care. All right. And I'm sorry, let me get back to you, Mr. Solomon. So he has a 2,000 felony bond. And I'm concerned if he makes bond and gets out, that there will certainly not be any victim intimidation or anything like that. I don't know if he knows her or if he doesn't. I am concerned about the allegations. I do know they're traffic offenses, but they're more than just suspended license and things of that nature. What kind of work did you tell me Mr. Solomon does?
He works at warehouse. The company name is Ram A Bio. Your Honor, he does not know Ayana Michelle, and I don't think that there will be any intimidation of the witness at all. And he's not a flight risk. He's been here for more than 15 years. He has mother, stepfather, and 3 siblings all residing here. He just had a baby. His girlfriend is here. He's not going anywhere, Your Honor.
All right, I'm going to order a $3,000 surety bond. That'll be $2,000 on the hit and run, $1,000 on the improper passing. And with that $3,000 surety bond, no drugs, alcohol, weapons, or guns while on bond. And no further contact with the victim. I'm not going to order stay away. I think at this point, Mrs. Mitchell, I think it's hard to say stay away from a certain street or just stay away from the Solstice Apartments, I guess, if he doesn't live there. I'm confused on what you're asking.
I'm more so concerned about the victim living there and him going back there as she was turning in there. We weren't able to confirm with the victim whether it was true or not, so that's why I issued that.
As long as Mr. Solomon, I'm assuming you don't live at the Solstice Apartment, so we'll just say stay away from the Solstice Apartments complex in Fairburn.
Okay, ma'am.
Okay. All right. So don't go to that apartment complex. And then that'll be it for the bond.
Thank you, Your Honor.
Mm-hmm.
Position 12, Mr. Townsend.
It's 23 CR 004740G. Danny Townsend, charge of 1 count of simple battery in a public transit vehicle or station, August the 1st, 2023. Pretrial.
It's 4th arrest. He had a 2019 ag assault first offender. I see a battery Nolo out of Gwinnett. Hold on, I'm sorry. Hold on. I didn't space those out. This is 4th arrest. Last arrest was 08, battery Nolo out of Gwinnett. I was reading wards, my bad.
Okay.
That's it.
Oh, okay. State.
Yes, Your Honor, in this case, the defendant is a MARTA bus operator and he battered Miss Mikiba, spelled Mikiba, Parker, a patron on the bus at the time. He battered her by striking her and throwing her up against the bus door. Officers were able to review CCTV footage, which revealed and confirmed the defendant hitting and throwing Miss Parker up against the bus door. Your Honor, the state's recommendation in this case is a $3,000 surety bond, a no further contact with the victim, 1 day anger awareness, and no alcohol, drugs, and weapons. Your Honor, as you heard, that there was a battery, the defendant pled NOLO to battery family violence in 2008. We understand that that's slight as far as violence in history compared to some of the other cases we may see in this courtroom, but it is still concerning to the state due to the fact that the defendant is a man who put his hands on a woman who was a patron on the bus that he was driving. And so we believe this is a public safety concern. We don't know if he's still employed with MARTA, but at this time we are requesting a $3,000 surety bond. Nothing further, Your Honor.
All right, P.D. Kim.
Yes, Your Honor. I had no chance to review the video footage. My client denies the allegation. He's the one who actually called the police. He also was kind of having a little bit of anxiety attack, heart attack at the time. So he's a bus driver. He's been doing that for like 8 years at MARTA. And Your Honor, 2008 is almost like 15 years ago. We don't have to consider anything beyond 10 years. He's a different person, and he has been working at MARTA bus driver for more than 8 years without any incident, Your Honor. We would like to request for signature on bond, and he does not know Miss Parker Mikiba, and we are totally fine with no further contact with her.
Okay.
Your Honor, the state would like to add, although the defendant may have been working for MARTA for 8 years with no incidences, we don't believe that this situation should be justified, being that it's okay for him in this one instance to put his hand on a patron on a bus that he was driving. Nothing further, Your Honor.
Yeah, I'm a little confused by the allegations. They are concerning to me.
Your Honor, I don't know if this is helpful, but I would like to add that our victim advocate, the police report or the warrant, I don't believe we have a police report in this. The warrant did not have a contact number for the victim. So our victim advocate is working with our investigator and ran a TLO and looking for numbers and attempting to contact the victim.
So you haven't had any victim contact?
No, nothing successful at this time.
It was my client who called the police, Your Honor, not the victim. And my client has a different story. He was having anxiety attack, and because Miss Patrick Parker was very abusive, Your Honor, he's presumed to be innocent, and I have not reviewed the video. I need to actually see whether that is really my client who's doing that. Please, I think he should be getting signature on bond.
All right, I'm going to order the $3,000 signature bond through pretrial per judge. I'm going to order that he take the 1-day anger awareness course through pretrial. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And stay away. Well, no stay away. I'm sorry, no further contact with the victim, Nakiba Patron. I thought you said her name was Patron. I may have the last name wrong.
Parker, Your Honor.
Parker. I'm sorry, Parker. No further contact with the victim. And that's all I order at this time.
All right, thank you, Your Honor.
Thank you, Your Honor.
Yeah.
Position 10, Mr. Simon.
What's the last name, Winston?
Huh? This is 23 CR 004738. Michael, is it Simon? Charged with 1 count of false report of a crime and 2nd count knowingly driving motor vehicle on a suspended, canceled, or revoked registration. Pre-trial?
This is 8th arrest. Last arrest was 2019, failure to appear. He's on probation for selling marijuana, 18 SC 161-898. Mostly his history is just drugs. I don't think I saw any driving related stuff.
Okay. State?
Yes, Your Honor, in this case, officer was dispatched to 3872 College Street, Atlanta, Georgia, which I believe is a parking lot, a side parking lot for McDonald's. in response to a theft call. Upon arrival, the defendant stated items were stolen out of his vehicle. Defendant stated his car was parked in that side lot of the McDonald's near Jonesboro Road. He went inside the McDonald's, he returned, and he noticed items missing from his vehicle, which include a denim jacket, an iPhone 14, and a check for $1,032. The defendant also stated that he had a key fob to his vehicle and it only locked on the driver's side. He stated he needed to report this so that he could notify his job to reissue him the check for $1,032. The officer proceeded with his investigation and retrieved camera footage from the parking lot. In the footage, the defendant is seen parking in the side lot and appeared to be walking around his vehicle while on his iPhone. Shortly after officer arrived in response to the theft call, the defendant did not go into the McDonald's, nor was anyone around his vehicle but him, as seen via camera footage. It was concluded that the defendant lied about the theft, and at the time, the defendant was also driving with a suspended registration. Your Honor, the state's bond recommendation is going to be $1,000 surety as to count 1, $1,000 surety as to count 2, totaling a $2,000 surety bond and no alcohol, drugs, and weapons. The state concern here is that there's a possibility of risk of reoffending because the defendant did plead first offender for felony drug possession in 2017. Pretrial already stated he has a history of drug-related charges, and he does have one FTA. So the state is requesting a $2,000 surety bond.
No other conditions.
Just no alcohol, drugs, and weapons.
Okay. PD Kim?
Yes, Your Honor. My client is 33 years old and he has been here in Georgia all his life. Your Honor, he is currently residing with his 4-year-old daughter, and he's the single father who's taking care of her. He resides, the daughter is residing with him, who has a sole custody. He has been working at Big Dave as a server. He graduated from high school. And Your Honor, my client denies the allegation, and he didn't know that his friend's car was not registered. Your Honor, we would like to request for a signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond, I would like to request for $1,000 total, $500 each. He already has a $5,000 surety bond from the felony court. So even that is very, very challenging financially. Thank you.
Mm-hmm. All right, I'm going to order a $2,000 signature bond through the jail. I'm going to order no drugs, alcohol, weapons, or guns while on bond. That's all I order in that case.
Thank you, Your Honor.
Mm-hmm.
Thank you, Your Honor.
That's $1,000 on each charge, Judge?
Yes.
Good. That's it. Position 13, Mr. Ward.
This is 23 CR 004741A. Mr. Ward, charged with 1 count of criminal trespass, pre-trial.
Third adult arrest. Last arrest was last year. Selling marijuana. That's 22 CP 210378. 2019 ag assault, first offender. That's it.
All right, state.
Yes, Your Honor. In this case, the defendant criminally trespassed onto Big Brother Mart located on 878 Norwood Road, Southeast Atlanta, Georgia. The defendant was previously given a criminal trespass warning on July 12th of this year by the same officer in this incident at the request of the store manager. The defendant was detained on the property. He also stated and confirmed that he was on the property because the store was the closest to where he resides, and he wanted to get a drink. The store manager stated that he would like to move forward with the charges. Your Honor, the state's bond recommendation in this case is a $3,000 signature bond, stay away from Big Brother Food Mart, and no alcohol, drugs, and weapons in this case. Nothing further, Your Honor.
Signature bond through whom?
Through jail, Your Honor.
Jail or pretrial? Ms. Mitchell, what's your recommendation?
That's fine.
I'm sorry, I didn't hear you.
Jail.
Oh, okay. All right, go ahead, PD Kim.
We have no objection, Your Honor. Thank you.
All right. I will order $3,000 signature bond through the jail. And please, Mr. Ward, stay away from the Big Brother Food Mart at 878 Norwood Road. That'll be part of your bond conditions to stay away. If you go back there, you're gonna be right back here. No drugs, alcohol, weapons, or guns while on bond. And that'll be it. You have a question about your bond conditions? You're muted.
No, I don't have a question about my bond hearing, but I have a question about my last case that I was arrested in.
Nope, not the right forum.
Yes,
Your attorney's telling you to be quiet, so I need you to do that. You can't
Thank you,
talk
Your
about
Honor.
your other cases. Thank you.
All right, position 14, Mr. Winters.
All right. This is 23 CR 004728E, Jaquarius Winters, charged with 1 count of criminal trespass and damage to property, July 31st, 2023. Retrial?
11 total. 2 2016, 1 2018 probation violation. 2015 entering auto, first offender. That's it.
All right, state.
Mr. Howard, what was his cycle? How many cycles he has? I'm just trying to make sure we have the same history.
Got 11.
Okay,
What do
okay.
you have?
11.
Okay.
Okay. Your Honor, in this case, the defendant damaged victim, Miss Jennifer Wilkie, spelled Wilkie. He damaged her mirror, valued at $70 during an altercation. The victim stated that the defendant is her ex-boyfriend / roommate, and they got into an argument that had escalated. The victim stated the defendant tore up the house and broke the mirror and grabbed her by the neck, pushing her up against a door frame as he was leaving the home. The victim did not have any visible injuries. There was also another witness, Mr. Jose Boreas Rangel, spelled BORIAS-RANGEL, who is victim's current roommate, who recorded an audio of the incident. Unfortunately, he didn't capture the defendant grabbing the victim by the throat, but stated that he saw him do it when he exited his room. The officer, mind you, the defendant and the victim no longer lived together. The officer entered the room and observed an overturned table and broken mirror on the ground. The victim is currently in jail on unrelated charges. I believe it's for a criminal trespass for Home Depot, where she received $1,000 surety bond. Your Honor, based on the nature of these allegations, our office plans to further investigate this matter and add the appropriate battery or aggravated strangulation charges after we get a chance to speak to the victim once she makes bond on her criminal trespass case. Your Honor, the state's current bond recommendation is a $5,000 cash bond, no further contact with the victim, Jennifer Wilkie, stay away from the incident location, which is her residence at 170 Creekmont Way, Creekmont spelled CREEKMONT, T. A one-day anger awareness and no alcohol, drugs, and weapons. Your Honor, this defendant is a high risk of reoffending. He currently has 6 open cases, plus this case, making it 7 open cases total. And I believe in this year alone, 1, 2, 3, he has 4 open cases from this year, and then 3 from last year, some of which include criminal trespass, theft, felony theft, felony drug, and just several charges. In addition to that, he was convicted of financial transaction card theft, possession of meth in 2016, and felony marijuana charge in 2016, which he is released on conditional discharge program, which is pending. I'm not sure that he will successfully complete that program based on his current history within the past year. So based on the nature of this offense and the amount of open cases he has, we're also concerned that he might be a flight risk. So we are asking for a $5,000 cash bond. Nothing further, Your Honor.
All right. Ms. McLeod?
Yes, Your Honor. My client is 29 years old. First, my client denies that the allegations in the warrant are accurate, Your Honor. He tells me that this is his home where he lives. The other thing he says is that the mirror that was allegedly smashed was his mirror because all of the furnishings in that house belongs to him. The warrant itself stated that the alleged other witness, who is supposed to be a current roommate, happens to be the ex of the complaining witness, and even the officer thought it necessary to put in the warrant that he did not believe that this was an independent witness. Therefore, any testimony that this witness may have given or probably plans to give going forward is to be taken with, as we would say, a grain of salt. My client does have some history, but the court will note that none of his history is violent at all. He is definitely not a violent person, Your Honor. And I do not understand the state's, the basis for the state requesting a $5,000 cash bond for a charge of criminal trespass. I would ask the court to consider giving my client a signature bond. He has open cases, but he doesn't have any convictions. I believe I heard one, and it was certainly not a violent conviction, Your Honor. And to allow him to return to his home. The alleged victim obviously has her own issues, and my client says that she was the one who was being aggressive with him. She's locked up in jail. That tells you something. I would ask the court to allow my client to go back to his home because that is his home and not hers. Nothing further, Your Honor.
All right. I'm going to order $2,000 surety bond. I'm going to order no further contact with the victim, Jennifer Wilkie. No further contact with her. If he says this 170 Creekmont is his, or there's any other evidence on his residence being there and not the victims, Ms. Mitchell?
Your Honor, based on the warrant, it appears that that is where the victim stays, not the defendant. The victim stays there with her roommate, Jose Barrios Rangel, according to the warrant. So I'm not sure where, it also states that the defendant is is her ex-boyfriend and ex-roommate. So I'm not really sure. Again, we didn't get a chance to speak to the victim. I can't confirm at this time.
And I believe the warrant also says that the alleged other witness is also an ex-boyfriend of hers. So it's a very complicated situation. But my client tells me that this is his home.
Yeah, it's hard to believe that they're all living in the same home and they're all her ex-boy. Again, it's not a situation I feel comfortable with, dismissing the stay away at this time.
It is his home, according to what he tells me. I don't know that the alleged victim said anything that was necessarily her home. My client even denies that any of he tells me that all the furniture in the house is his. And
Yeah, let me sound for
the
but he
officer noted that he didn't, the other witness was someone who was her ex. So anything he said was to be taken with that in mind. That
I'm
was
not gonna
warrant.
try
I
to.
saw that myself.
Right. I'm not going to try to weigh the evidence at this point or the witnesses' credibility. But I'm going to order a one-time law enforcement escort back to that property so that he can retrieve his personal items. And as I've said in the past, if the officer sweeps that residence and determines that the victim or there's no items in that location belonging to a female, then he can stay there if it appears that this victim does not reside there. They go there and she answers the door, she's there, then obviously he cannot stay there. So it's only returning one time to remove personal items or staying if the officer sweeps the residence and determines that there are no items belonging to this female at that residence.
Judge, she's currently at the Fulton County Jail with multiple cases. It's home for the
So he's not going anywhere.
She's not going nowhere. The victim, she's at the Fulton County Jail also at this point, and she
Because they said arrested on other charges. Yeah. But her bond was only 1,000 surety, I thought.
Well, she has several cases and stuff that she
Oh.
already appointed Judge Morrow yesterday, and he implement the bond heavy. So she has four cases that's on an upcoming counter. And
Oh,
I don't
okay.
think I don't think she can make the bond.
All right. Well, I will remove the stay away and remove the one-time escort, and we'll hope for the best to see if he returns to that location. I guess if he returns there and gets an altercation, he'll be arrested again.
But she's not even there. Even if he gets out before she does, he gonna be there. She's not, because she's still locked up in Fulton County Jail.
Yeah, the worst things have happened. Some people get bonds and they get out and get friends to do it, and they're out the next day. Hopefully she won't be, and there won't be any more altercations. So we'll see what happens, Mr.
Well, Your Honor, I've instructed my client to not have any contact with her going forward.
Right, and that's what my bond order says, no further contact with the victim. So you got to use your best judgment, Mr. Winters. If you go back there, she's there. As much as you may want to stay there and it's your location so that you stay out of jail, I suggest you leave, even though I'm not going to order the stay away just in case she isn't there. You get me? Don't want to sound confusing.
Yes, ma'am.
Okay.
And if
All
while
right.
you're there, she comes there, you should call the police, not have any interaction with her.
Yes,
Yeah. Okay. I think
The
that's
judge is
good
no
advice.
stay away. It's just pretty much no further contact with the victim.
Correct.
And it's a $2,000 surety.
Yes.
Okay, and no alcohol, drug, and weapons.
Yes, I forgot to say that. Thank you.
All right.
Thank you.
Okay. Thank you.
Thank you.
Your Honor, that's it for courtroom 2. Position 9 is a medical reset.
Okay. And that's it for today.
Yes, ma'am.
All right. See you next time. Thank you.
All right. Have a good day.
Too.
Yes, that's the clues account. I guess I can go over it.
Yeah.
Everybody ready? Remember the SAP reset date is August the 15th. Okay, position number 1 is a total of a $3,000 surety. The case is reset for the SAP. Position number 2 is a $1,000 surety reset for the SAP. Position number 3 is a $1,000 SOB through the jail reset for the notice. Position number 4 is a total of a $4,000 SOB through the jail reset for the notice. Position number 5 is a $1,500 surety bond reset for SAP. Position number 6 is a total of a $3,500 signature bond through pretrial per judge reset for the notice. Position number 7 is a total of a $3,000 signature bond through the jail. We set further notice. Position number 8 is a total of a $3,000 surety bond. We set for SAP. Position number 9 is a medical reset. It's going to reset to tomorrow SEA counter, which is August the 3rd. Position number 10 is a total of a $2,000 signature bond through the jail. We set further notice. Position number 11 is a total of a $3,000 surety bond. We set for SAP. Position number 12 is a $3,000 signature bond through pretrial per judge. We set further notice. Position number 13 is a $3,000 signature bond through the jail. We set further notice. Position number 14 is a $2,000 surety. We set for the SAP August the 15th. Any questions, concerns, or corrections?
Hello?
Nope.
All right.
Sounds good. Thank
Thank you.
you.
Judge, I'll get those orders right over to you.
Yes, ma'am.
All right.
Alrighty.
Thank you.
Bye-bye.
Bye-bye, everybody.